Hi everyone, my name is Amber Rouse Holloway and I'm a partner here at our Troy office, and this is the February 2022 episode of my PIP Monthly. Our February 2022 topics include, of course, a case law update. First, I'm going to be talking about the case of Mobile MRI Staffing v. Mimic, issued January 20th, 2022, and then Precise MRI of Michigan v. State Auto. This was issued, it's actually a binding decision, and it came out in early 2022 as well. And in that case, State Auto was indeed represented by Secret Wardle. And then moving on to trending topics and PIP litigation, I'm going to talk about Public Health Code, or MCL 333-17047, which deals with PAs or physician's assistants and the requirement that they have a practice agreement and how that coincides with the No Fault Act. All right, so first up, we have Mobile MRI Staffing, LLC v. Mimic Insurance Company, and this is an unpublished opinion that was issued on January 20th, 2022. This case deals with the No Fault Act and the recent amendment on June 11th, 2019, which significantly changed the one-year back rule. What used to be a bright line in cutting off expenses incurred more than 1 year before the date the suit was filed is now subject from the date a specific claim for payment of benefits until the insurer formally denies the claim. And that's MCL 500-3145, Section 3. There is an exception to that nuance, and that's when the person seeking payment or the plaintiff or claimant does not act with reasonable diligence. So now the one-year back rule is told by 3145 from the date a specific claim of payment of benefits until the date the insurer formally denies the claim, unless the person seeking the benefits has not acted with reasonable diligence. So here we have an issue. There's going to be an issue versus deny or suspend in litigation, and there may also be issues as to what reasonable diligence is, or the term reasonable, and what does that mean. So obviously this new rule benefits plaintiffs and claimants, and they want to have this rule applied to as many cases as possible. But in the instant matter for this specific case, the panel held that the 2019 amendment had no retroactive effect and the prior version of the statute controlled. Here, the Mobile MRI was filed after the effective date of the amendment, so after June of 2019, but the panel explained that the critical date here is when the cause of action accrued, not when suit was filed. The provider was seeking payment for services that were performed in July of 2018, and the panel applied, the Court of Appeals panel applied the version of the statute at that time. So essentially they said that any benefits prior to 1 year prior to July of 2018 were barred. I did want to give a brief description of the specific facts of this case. So in Mobile MRI, the panel considered a provider's claim for 3 magnetic MRI scans performed on July 25th, 2018. Mimic made a payment to the provider on April 3rd, 2019, but the payment was less than the amount requested for whatever reason. Plaintiff then filed suit for the balance or a balance bill on November 13th, 2019, after the June 2019 amendments took effect. So therefore, according to the old statute, any benefits, and I'm making a correction to myself earlier, any benefits prior to November 13, 2018 are barred. So here, plaintiff is seeking payment for services that took place in July of 2018. So approximately 5 months of the treatment was barred. During the analysis, the court started from the foundational presumption in Michigan against retroactive application of new legislation. The court said that statutes are presumed to apply prospectively unless the legislator clearly manifests an intent for retroactive application. The panel read through the amendment of the No Fault Act and found no such language, and the use of the phrase immediate effect does not at all suggest that a public act applies retroactively. It means it applies from this day forward. The court held that although the plaintiff filed suit after the amendment, the relevant inquiry in determining the applicable statute is the date on which the action arose. Generally, a claim accrues at the time the wrong upon which the claim is based was done. So this case, although not binding, is a very strong case. It's held that the suit and mobile MRI was filed after the effective date of the amendment, but the panel went on to explain that the critical date is when the action accrued, not when the suit was filed. So this is a case you may want to use in situations where you file a motion for summary disposition on 1 year back and the plaintiff is arguing that the new statute applies and not the old one. Next up, we have the case of Precise MRI of Michigan, LLC v. State Auto Insurance Company. Ultimately, the court held that no-fault carriers are required to reimburse providers for MRIs prescribed by chiropractors only if the MRI was taken of the individual spine or if the MRI was used to locate spinal issues. Here, the Court of Appeals was asked to determine whether MRI scans were included in the definition of the prior practice of chiropractic and MCL 16401 as of January 1st, 2009. The Court of Appeals held that because the MRI scans were taken of the spine, the MRI scans were within the scope of chiropractic practice and thus compensable under the No Fault Act. By way of background, the claimant here underwent 6 MRIs following a July 2019 motor vehicle accident. 4 of the MRIs were prescribed by Dr. Ray Chuney, a chiropractor. The MRI scans were related to the claimant's cervical spine, thoracic spine, and lumbar spine. Defendant refused to reimburse plaintiff for the MRIs because the MRIs were prescribed by Dr. Ray Chuney, which would make them unlawfully rendered because MRIs are not defined under this practice of chiropractic. Specifically, it only defines or advises that the chiropractors may prescribe x-rays and not MRIs. I take that back. It does not specifically say they cannot prescribe MRIs, but it is silent as to MRIs, but does specifically indicate that x-rays are within the scope of chiropractic care. Here, the defense cited MCL 3107B and asserted that reimbursement was not required for a practice of chiropractic service unless that service was included in the definition of the practice of chiropractic under the same statute as of January 1st, 2019. Defendant contended that the statute specifically limited chiropractors to ordering only x-rays and not MRIs to locate their spinal issues. Plaintiff conversely argued that the MRIs were compensable under the No Fault Act because they were related to the claimant's spine. While in appeal in Precise MRI, while this was pending, the court issued the opinion in the case of Skewerwork v. Weshnet, and that's docket number. Well, I have it listed here if you guys need it, which held that when an MRI is used for analysis of a spine, it falls within the scope of chiropractic as it was defined on January 1st, 2019. Ultimately, this court also found that the MRIs of the thoracic, cervical, and lumbar spine fell within the definition of the practice of chiropractic, and there was also an MRI of the sacroiliac joint, but that also fell within the definition because it comprised of a part of the claimant's spine. The court cites the Hoffman v. Auto Club case, which explained that the purpose of the pelvic x-ray was to determine the existence of sacral subluxation, which makes up part of the spine. And since the pelvic x-ray was taken for the purpose of locating sacral subluxation, it's authorized by the statute. Therefore, MRIs of the T-spine, C-spine, lumbar spine, and even the sacroiliac joints that were prescribed by Dr. Ray Chuney were compensable under the No Fault Act here. Moving on to trending topics in PIP litigation, I wanted to talk about the Public Health Code MCL 333-17047, which deals with the practice as a physician's assistant and their practice agreement. So by way of background, this issue would come up if during the course of discovery you obtain records or the plaintiff testifies at their deposition that a PA treated them, a physician's assistant treated them, and then you find out somehow that the PA did not have a practice agreement during the course of the treatment, but then this PA subsequently prescribes treatment. They may prescribe physical therapy or write a disability slip or even prescribe medication in some circumstances. So under MCL 333-17047, a physician's assistant shall not engage in the practice as a physician's assistant except under the terms of a practice agreement that meets the minimal requirements of the section. So from my understanding, and I've talked about this issue, I have a very close friend of mine that is also a PA, and I've talked about this issue with her. From my understanding, the practice agreement is an agreement that is entered into almost as soon as you start your employment, and the doctor that is assigned to the PA, so is the one who crafts the practice agreement. And so the doctor may be the lead doctor and then have several other PAs under the same practice agreement, is what my understanding is of the agreement. And that practice agreement outlines the course of their relationship and how things are going to go in their relationship, who does what and who does the other things, and what the PA is allowed to do. I won't read all of the section 2, but essentially it talks about that there must be a process that is agreed to, that talks about the availability, communication, and decision making between the two parties. And it might be more than two parties in an agreement, but between at least the physician and his assistant. But most importantly, there is a requirement that the doctor verify the PA's credentials in that practice agreement. So if there is a lack of a practice agreement and a PA is practicing under MCL 500-3157 Section 1, that is unlawful treatment. So MCL 500-3157 Section 1 requires that treatment be lawfully rendered to an injured person covered by personal protection insurance. So essentially, a physician or institution lawfully rendering treatment may do so if the treatment is reasonable. So here, the hang up is on the word lawfully, must lawfully render treatment. And if a practice agreement is required under the law and there is no practice agreement, then the treatment is not lawful, obviously. Recently, we have had some pretty successful motions on this issue. The big hang up is making sure that you are able to discover this information during the course of discovery. And when it is discovered, it's kind of like tree branches. So you get this one issue, and then that PA has prescribed disability, and then the plaintiff is out on disability for 6 months. But now, arguably, you have the argument that the plaintiff was not disabled or was unlawfully disabled, and now the treatment from the PA and the disability are into question. So it's important to find these things out during discovery. But that is really all I have for you guys today. As always, thank you for attending my PIP Monthly. Please feel free to contact me with any questions and or concerns you may have. Thank you.